simply access to information that the public is entitled to. So if they're intervening for that purpose, we don't object. Apparently, they believe that this case is more about a recount or stopping or stalling the recount. It has nothing to do with this case.
And I have reviewed the complaint that appears what the request is for. It's specifically a public records request pursuant to the Florida Constitution as well as pursuant to Florida statute.
Absolutely, Your Honor.
Yes, sir.
Yes, ma'am, you heard on their intervention on behalf of the Florida Democratic Party. The letter attached to the complaint,
yes, sir,
which is a public records request public records, and says in part, we request that you stop canvassing ballots immediately. So 2 points. One is I was actively involved in representing the Florida Democratic Party in the 2000 recount on behalf of Cora Lieberman. I don't recall a single case in which the Republican Party was involved and the Democratic Party was not allowed to intervene, or vice versa, by consent or by making an appearance or being sued. So part of their request is to stop canvassing ballots. It's in the letter, and I direct your attention to the first full paragraph on page 2. As the Florida Democratic Party, Your Honor, we have a lot of voters in Broward County. We have voters who have provisional ballots. We have voters who have absentee ballots. We have voters who have military ballots. We have voters who have regular ballots. We have voters who have mail-in ballots.
If I could just stop you a second, counsel, I realized that that exhibit was attached, but it wasn't attached as the relief requested in the complaint. It was attached as an exhibit showing that they had requested information, and that information has been denied as of, I believe at this time. Currently, has that information been provided, counsel?
No, Your Honor.
Okay, so within the complaint, if you could just hear me out, if you look at the complaint in paragraph 12, Roman numerals 1 through 7, and if you look at the wherefore clause, nowhere within paragraph 12, Roman numerals 1 through 7, nor within the wherefore clause, other than C, grant any further relief as the court deems appropriate, is there a request to stop counting?
Well, that letter, though, should tell you what exactly is in play here, and it is part of that because there's a public records request. They want this done in 1 day. The supervisor election happens to be a little busy now and tied up. They're counting votes. It's all hands on deck to meet the certification deadline of November 10th. There are other times in which they can get
Sir, if
yes.
you could get to your motion to
Sure.
intervene,
Yes.
and rather than making an argument.
Well, the motion to intervene is tied in a bit to the argument because our concern, and why we want to be in this case, is our concern that their public record request will hamper the ability of Broward County voters to have all of their votes counted while they're dealing with side issues.
Okay, well then, for those, for that limited purpose, counsel, do you have any objection to them intervening with regards to making that argument?
Briefly, Your Honor, yes, because I believe their intervention to make that argument would be a sideshow to the very nature of their action that was brought. Our wherefore clause, as you rightly identified, does not mention anything about stopping canvassing. We tailored this lawsuit to the issue at hand, access to the information that we think we're entitled to. It has nothing to do about canvassing votes, and frankly, Your Honor, the information that the supervisor of election did not provide to us is required by statute that she has, specifically 18-1S-2.043. She should have already submitted that information to the Department of State, so that information should be readily available. This should not be a drain on resources and interfere with the supervisor of election. However, I want to end with, Your Honor, we were very careful with this complaint to narrowly tailor it to the relief we're seeking. This has nothing to do about counting votes. This has nothing to do about inspection of votes to decide whether or not they're in or out. This is simple information about how many votes are left to be counted, how many votes are counted, and these daily reports that she's required by statute to provide.
Yes, sir.
Your Honor, they've asked in their letter that
The letter isn't the request, though.
and what they are seeking here is to have copies and inspections made of
Pursuant to the
information.
Florida Constitution and Florida statutes?
The Florida statute, which says they should be provided in a reasonable time, under reasonable circumstances, under reasonable conditions, not the next day when they send a letter, file a lawsuit, and have a hearing all within the course of 24 hours during an election, to have the supervisor's office stop. We have a definite interest in that as the Florida Democratic Party.
I will grant the motion to intervene without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
Yes, sir.
So we argued a little bit about the substance of our complaint at this point in the immediate request for a hearing. I want to address 2 quick points, Your Honor, outside of what's in our complaint. The fact that the Florida Constitution, the Florida statute, provides public access to information such as this is unquestioned. Chapter 119 specifically references ballots and ballots information within what is permitted as a public record. In fact, this morning, we had a case in Palm Beach County regarding public records of ballot information, which the Florida Democratic Party brought, and it was undisputed that this type of information is a public record. So I don't believe we have an issue about whether or not this proprietary of this information is a public record. Second, under the reasonable time and reasonable circumstance issue, there is nothing more fundamental than the protection of our vote. The fact that the supervisor of election in Broward County is not providing information that she's required to provide is simply concerning, Your Honor. That is the reason why this request was made yesterday, because the information that we requested as a firm on behalf of our clients is information that the supervisor of election should have already compiled and should have already submitted to the state. There should be a text delineated file on her computer that contains this information. That's what 1S 2.043 says. If that's not there, we have a whole different issue. But our response that we got from the supervisor of election was nothing. We sent a runner, we actually sent a partner of Bear Robinson to the supervisor of election, hand-delivered the public records request. They didn't give us a time, they gave an explanation, they didn't give us any records.
If I could just stop you there
Yes,
for a
Your Honor.
moment, counsel. When was the letter delivered? At what time?
I believe the letter was sent sometime after 12 till before 1 yesterday afternoon.
Between 12 and 1 p.m.?
Yes, Your Honor. And I want to say, before that time, we had been working and calling and dealing with the supervisor elections, not just of Broward County, but of all counties to get the same information. Some counties were providing that information. Some counties it was easy to provide. Some counties we had multiple conversations. Yesterday morning was when we realized that we were not going to get the information from the Broward County supervisor of election. She was not going to provide that information to us. That's the reason why we drafted this public records request in the morning, figured out which documents that she would have readily access. We did not want her to create documents because we knew that that wasn't a valid public records request. We didn't want to take her away from the job of counting the ballots. We wanted documents that were very specifically tailored that wouldn't interfere with her duty to count these votes. And that's what this list is. These are narrowly tailored requests that she should have already had and produced to the Department of State that should be one click away on her computer. This is not a burdensome request. This is not something that's exempted by Florida law. This is a simple request that the supervisor of election should have provided. And, Your Honor, I want to add in our letter, and as we stated at the supervisor of election, we're happy if the information goes to both parties, all parties. This is not a partisan issue. We want this information to be produced. It can be produced publicly, it can be given to us, and the other side, as soon as it's ready, it can be put on a website. This information needs to be public. That's the sole purpose of this. And finally, Your Honor, I want to buttress that argument with the fact that Chapter 119.07 sub 5 specifically talks about public requests of ballots. There's a section in it regarding ballots during an election. It is not something that is foreign to this legislature who created the statute or the Florida Constitution that a public records request happens during an election, and that requires certain handling. We asked for that handling. We asked to follow the statutory framework of Chapter 119 to request these records during the elections. That is not something that is rare. That is not something that the legislature didn't foresee. That is specifically covered in the statute. So we believe that a request yesterday for information that was readily available, provided to both sides, should have been produced, and we believe that a failure to do that does not meet the reasonable time and reasonable circumstance standard of Chapter 119, and we ask the court to immediately order the supervisor of election to provide this information and find that she violated this chapter. Thank you, Your Honor.
Yes, sir.
Yes, Your Honor. Eugene Pettis on behalf of Dr. Snipes. Counsel is right. We all recognize that we're talking about public records information here. This is all about timing. Let the record be clear. Dr. Snipes has never told them that she would not provide the information. They just delivered it 26 hours ago. Let's talk about what she's been doing the last 26 hours. Yesterday, they convened the canvassing board. Judge, they were there at 10 o'clock later last night, arguing about all sorts of election issues, and Dr. Snipes was there doing that. He indicated there's nothing more fundamental than to protect the vote. I think there's something equally fundamental, and that's to count the votes. And that's what they've been busy doing. I represented a lot of public agencies, and I fought over a lot of public records requests. I've never heard one to argue, and I've been on both sides of public records requests, making the request and addressing the request, that 26 hours is somehow reasonable time in the context of what we have going on. In their complaint, they say they've been doing this, Judge, since the 6th, which happened to be Election Day. They didn't make an official request to yesterday. Dr. Snipes is not in violation of any statute. There's no interpretation, Judge, that can say that 26 hours of time in the context of what she's been doing is somehow validative of anything. She's going to fulfill her duties and responsibilities in a reasonable time that and I've spoken to make sure that she never denied, because I didn't see anything of record, that she didn't deny them access to any information that's in that elections office. But Judge, we must give reasonable time, just as they believe, and they concluded, what he said, Judge, was not that Dr. Snipes told them that she would not provide it, but they decided that she was not going to provide it. But that's not the role of any lawyer. I can't tell you, nor should they be able to tell you, Dr. Snipes has spoken, and Dr. Snipes says she has no denial of that information. She's going to provide it to them within a reasonable time. We can talk about what a reasonable time frame, Judge, is with regard to the canvassing board requirements that are going on, counting the ballots that are still being counted. That's obviously public knowledge, and to making sure that all the information is there. We have until noon tomorrow to do a preliminary certification to the state. That's not yesterday. That's not today. That's noon tomorrow. And we're dealing, Judge, with, and we can, I understand what the complaint says, but you appreciate the backdrop of this is that Governor Scott does not believe that it's moving fast enough. That's what he said on TV. I'm just going to take him at his word. That it's not moving fast enough. Therefore, they've intervened to speed this up. Well, Judge, that's inappropriate. To intervene in the middle of this process and to somehow interfere with what's going on, and that's the fulfillment of her constitutional obligation to count the votes, to respond to the canvassing board, and then to address these requests. You don't intervene and get in the counting process, whether they're saying it or not. They're interfering with the counting process, which should be Dr. Snipes' primary responsibility, and certify that by tomorrow noon. And thereafter, she's going to have to respond to the public rights requests and all sorts of requests that have been made to her in the midst of all of this. The record is clear. She is not denying this is public information. She's not denying them to provide it to them, but she must be given more than a day. And they didn't wait for the full 24 hours. They filed this after minutes of the request. This got filed yesterday. We're now 26 hours after they first served the letter. They gave her minutes. You didn't respond. We're in court. That's just not the way public records provisions should be utilized in this state, and that should not be tolerated, Judge.
Good afternoon, Your Honor. Scott Andrew from the County Attorney's Office on behalf of the Broward County Canvassing Board. Your Honor, if this is indeed merely an act related to records in the possession of the supervisor of elections, the canvassing board doesn't obviously have an interest in that. We are concerned, of course, based on some of the statements made by my colleagues and their client. However, yesterday, particularly an announcement made before the press yesterday by the governor that he was concerned there was fraud here in Broward County and other concerns about the counting of votes. So we're mainly here to make sure that if there's any relief awarded that affects our ability to count votes, that we have the opportunity to be heard. So far, I haven't heard that.
Yes, sir. Neither have I. Neither have I read.
Thank you, Your Honor.
Yes, sir.
Yes. Thank you, Your Honor. So on a public records request, and we are concerned, Your Honor, given all of the deadlines coming up, including by November 10th, there could be a machine recount. There's a lot happening right now, as Mr. Pettis spoke about, to go aside. But more importantly, Your Honor, as a matter of law, there is no case in the state of Florida where a public records request had to be complied with within 24 hours. Now, there's a lot outside this courtroom going on, allegations about this, allegations about that. None of that is before your court in any verified pleading or otherwise in terms of any wrongdoing going on in that case. And there have been reports about the Department of Law Enforcement. Steve Bosquet reported today, Your Honor, the Florida Department of Law Enforcement says it is not.
Yeah, I'm going to sustain the objection. I am not here for anything outside of the pleadings and the request made within those pleadings.
Okay, I understand, Your Honor, but there are things happening outside that are of concern because the case is, this would be an unprecedented ruling, Your Honor, to read the statute that says that public records shall be inspected and copied by any person desiring to do so at any reasonable time under reasonable conditions and under the supervision of the custodian of public records. There is no case where 24 hours is a reasonable time. If there are ever not reasonable conditions to require stop and produce these documents while an election is going on, while certification has to be required, while there's likely to be a manual recount of at least one, maybe three, maybe four, I don't know, and maybe beyond that a hand recount. So Mr. Pettis represented the court. I've known him for years. He represented the court that things will be taken care of, but to order it when there's been no finding of any wrongdoing by the office, and by the way, that can always be handled in an election contest later on if they believe that to be the case. It simply would be unprecedented. There's no precedent for this, and like I said, there cannot be a worse time to order a 24-hour drop everything, give them the documents. Thank you, Your Honor.
Yes, sir.
Your Honor, briefly, all the outside issues have nothing to do with this case. And I respect the canvassing board attorney for saying and recognizing that this is a very narrow case. This is not a drop everything type of public records request. We didn't ask for every email communication, every text message. This is information that the supervisor of election should have already compiled and saved as a text delineated file on her computer. This should take 10 minutes to do, Your Honor. And so, Your Honor, when under a reasonable time and under a reasonable circumstance, 24 hours to me, Your Honor, is more than enough time to comply with this public records request. This statute specifically recognizes there are situations where a public records request will be made during an active election. The public records request doesn't bar request during that period. The act doesn't say you can't do it. You got to let the supervisor of election do one of her constitutional jobs before she does her other constitutional job. There's no law regarding that. There's no requirement of that. The supervisor of election has a constitutional duty to respond to this public records request. She did not deny the request, but she hasn't responded. The not responding is denying the public records request. This is a simple public records request that the supervisor of election should have and she could be able to comply with within 10 minutes due to the requirements of the Division of Elections in the Department of State. Your Honor, we believe that we're entitled to an order compelling the supervisor of election for Broward County to produce these public records within 2 hours, because this information should be there, unless the supervisor of election is telling me that this information doesn't exist, which then is a whole different issue.
Yes, sir. Okay. I did just receive this complaint this morning, and since this morning until this afternoon when this hearing began, I have been reviewing all of the documents, going through the Florida Constitution as well as Florida statutes, going through the Attorney General opinions with regards to previous cases that have been brought before the court. And upon review of all of that, as well as specific cases, and one of the issues that has been brought up during the hearing and hearing the arguments from both sides with regards about justice and delaying, I reviewed a very recent case out of the 4th DCA with regards to the state attorney's office and the school board of Broward County versus Cable News Network. And within that opinion, it talked about the Public Records Act is to be construed liberally in favor of openness, and all exemptions from disclosure construed narrowly and limited to their designated purpose. When in doubt, the court should find in favor of disclosure rather than secrecy. And they also go on in the concurring opinion to talk about this and essentially say that justice delayed is justice denied. Reviewing Florida Statute 101.5614 talks about the canvassing of returns, talking about the reasonableness of time, because I wanted to know, and that was why I had one of the first questions with regards to when was this letter presented, when was the request made, and I found the Florida Statute 101.5614, subsection 1. As soon as the polls are closed, the election board shall secure the voting devices against further voting. The election board shall thereafter, in the presence of members of the public desiring to witness the proceedings, verify the number of voted ballots, unused ballots, provisional ballots, and spoiled ballots to ascertain whether such number corresponds with the number of ballots issued by the supervisor. If there is a difference, this fact shall be reported in writing to the county canvassing board with reasons therefore, if known. And the total number of voted ballots shall be entered on the forms provided. That is on the very moment that the polls are closed, as soon as the polls are closed. And then I went on and I did some research with regards to election dates. And it has been argued here, no later than tomorrow, Saturday, November 10th, is the deadline for the county canvassing boards to file first unofficial results of the general election with the Department of State, pursuant to sections 102.141 Florida statute, no later than noon of the fourth day after a general election. With regards to Florida statute 119.07, inspection and copying of records, 1A, every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so at a reasonable time, under reasonable conditions, and under supervision by the custodian of the public records. Going on to paragraph 5. When ballots are produced under this section for inspection or examination, no persons other than the supervisor shall touch the ballots. If the ballots are being examined before the end of the contest period, in 102.168, the supervisor of election shall make a reasonable effort to notify all candidates by telephone or otherwise of the time and place of the inspection or examination. All such candidates or the representative shall be allowed to be present during the inspection or examination. Further, pursuant to the Florida Constitution, Article 1, Section 24, access to public records and meetings. A, every person has the right to inspect or copy any public record made or received in connection with official business of any public body, officer, or employee of the state or persons acting on their behalf. This section specifically includes the legislative, executive, and judicial branches of government, and each agency or department created thereunder, counties, municipalities, and districts, and each constitutional officer, board, and commission or entity created pursuant to law or this Constitution. Going back to 2001, when the Attorney General was Bob Butterworth, and he wrote a legal opinion, 2001-37, an advisory opinion, and discussed other cases that had been brought. Sentinel Communications, Inc. versus Anderson. Also, Knightbrider, Inc. versus Stafford. And in his Attorney General opinion given, he discussed the allowance of this information to be disclosed. And these were cases that were going on, once again, during the election as the votes were being counted. This was an overvote and undervote ballots. With regards to the complaint that had been filed in this case, again, this complaint did not discuss the issue of fraud. It did not discuss other issues that have been brought up here that may be transpiring or heard on TV, or heard out on the street, heard on blogs, heard in Twitter, social media, I don't know where. But the only thing that this court is concerned with are the pleadings before the court here today, and the emergency complaint that was filed in this case to enforce the Florida Public Records Act and request for immediate hearing. We are here because the court, pursuant again to Florida statute, an immediate hearing is required, and that's why we are here this afternoon immediately. Hearing argument from everybody, having reviewed the Florida Constitution as well as the Florida statute, as well as the Attorney General opinion, going way back to 2001, nearly 17 years ago. This court finds, once again, Broward County is under the microscope and being viewed by the entire nation. And reviewing, hearing argument, this court finds that there has been a violation of the Florida Constitution, the Florida Statute, Public Records Act, and pursuant to the applicable case law. The supervisor of elections, Supervisor Snipes, shall allow for the immediate inspection, copying, photocopying of the requested records in paragraph 12 of this emergency complaint, Roman numerals 1 through 7. Again, it's this court's understanding and hearing argument from counsel that this is information that should have already been compiled, already be within the system. And if it's not already in this system, that's a whole nother issue that has not been brought before this court. It should be there. It should not slow down the proceedings. It should be a matter of record at this point. The additional request, when in paragraph C, where it says grant any further relief as the court deems appropriate, the additional relief would be that there shall be no spoliation of the records requested pursuant to Florida Statute 119.071A with regards to request Roman numerals 1 through 7, and that the request shall allow for the immediate access of the requested public records, and by immediate request I mean on or before 7 p.m. this evening. And I will prepare a written order as well. That's my verbal ruling for now,